Hello, everybody, and welcome to this. We have a meeting that is going to be done in two parts. The first part, of course, will be about a review pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, September 19th. The committee commences its study to review changes made to the Fisheries Act of 2012. Now, in the second hour, we'll be talking about the supplementary estimates of votes to be taken, and we'll have officials from the Department of Fisheries and Oceans and Coast Guard. In the meantime, let's get to our first hour, and we have two distinguished guests with us today. We have, from the West Coast Environmental Law, the Staff Counsel, Ms. Linda Nolan. Thank you, Ms. Nolan, for joining us. And as an individual, which is quite an distinction there, sir, Otto Langer, fisheries biologist, no stranger to us, of course. And Mr. Langer, we welcome you also. The way this works, as you know, and for those of us around watching, we start with 10-minute introductions. You can start your speech on this particular issue for 10 minutes, roughly. Hopefully you'll be 10 minutes or less. And then we open up the floor to questions and comments. So, Mr. Langer, I'm going to start with you, sir.
Thank you, Mr. Chairman, co-chairs, members. My name's Otto Langer. I'm a fisheries biologist. I've been involved in fisheries biology across Canada for about 50 years now, and I spent about 33 of those with Department of Fisheries and Oceans and Environment Canada. Some of the comments I make, I think, will go beyond DFO and amendments to the Habitat section of the Fisheries Act and the Fisheries Act. And I think a lot of my comments relate to Environment Canada and at times even the Transport Minister. Habitat and water quality in government has been a political football in the 50 years I've been around. Certain governments are in place, and they want to turn off the civil service and would like to hide the Fisheries Act. In fact, when I was with government, at times we were told no one wanted to see a copy of the Fisheries Act on our desk. And unfortunately, the resource base suffers when we see these ups and downs. Now we're into about a 16-year down cycle, unfortunately. Looking at the Fisheries Act amendments we can make to it, I'd say that's only a quarter of the issue. You need good legislation. However, you need good political direction with some balance of science in that political direction. You need a strong will within the agencies to do the job. Right now, that doesn't exist. And you need the organization and the resources to do the job. We've reached a low point in, I think, the last 50 years where our legislation's gone downhill. Political direction has been terrible in the recent past. There is no will in DFO to do the job or Environment Canada. And the organization is suffering a lot, and the resources have been cut, especially in 2012. I've done a great deal of history of the Fisheries Act and how the work's been done, including affidavits to the BC Supreme Court. I was considered an expert on the habitat pollution provisions of the Fisheries Act, so that was tendered as an affidavit. I'm not going to go into that. I think my brief's 100 pages long. I just want to dwell on the first 7 pages. Prior to 1967 and myself joining the Department of Fisheries and Oceans from the University of Alberta, there was no real habitat law in the Fisheries Act of any sort other than to look at blockages from dams, low flows below dams, and there was a section of the Fisheries Act that said when you were logging you couldn't put debris in the stream. However, we were losing a lot of streams in British Columbia due to gravel companies, logging road builders. They were mining gravel directly out of the spawning beds of salmon streams. So in 1967, the government was convinced to put an order in council through, and a BC gravel removal order was put in place, and that is the first beginning of a habitat law in Canada. Then in 1976, some of us campaigned for a couple of years to get habitat protection of the Fisheries Act, and Parliament, in its wisdom, passed the habitat section, which we call HAD, harmful alteration, disruption, destruction of fish habitat. We saw that as a giant step forward. That seemed to create a lot of confusion in Canada, so that was followed up with a defining policy, which some people refer to it as the no net loss policy. It was a national fisheries policy, and it received a lot of good feedback from around the world in terms of being one of the first sustainable development policies on Earth. So we went from the 60s and 70s of a rapid net loss of fish habitat with no net loss and the HAB provisions of the Fisheries Act. We didn't achieve zero loss. We were at a point where I'd call it a slow net loss. In the 80s, we reviewed projects through the FERO process, the Federal Environmental Assessment Office. We had no Canadian Environmental Assessment Act. We had regional screening coordination committees. And actually, quite a good job was done without legislation, just orders in council. 1995, we had SIA come along. And unfortunately, SIA was greatly watered down in 2012. For instance, in British Columbia, went from 495 to 5 reviewable projects. And for instance, an example is a jet fuel terminal in the Fraser River, probably one of the worst places to put a jet fuel terminal in the middle of a world-class estuary. In 1988, when the airport consortium tried to put it in, the federal government held a proper FARO review, and the project was rejected as too great a risk to the Fraser River. 2011, the feds weren't even there. They had delegated the review to the Fraser River, to Vancouver Port Authority, and the feds didn't do a review of any sort. Environment Canada Fisheries just disappeared from the scene, and the project is now approved, and it's 10 times larger than what was rejected in 1988. There's something wrong in Canada right now in terms of where is DFO, where's the legislation, and we're at a point of rapid net loss of habitat again. One big thing that we lost in SIA was the fisheries law trigger. If there was a harmful alteration, it triggered a proper environmental review. The Harper government did remove that, and that was a giant setback. That also applied to the Navajo Waters Protection Act, as that act and the Fisheries Act did complement each other. In summary, I'd like to say that we are here in 2016. We've lost habitat protection provisions in the Fisheries Act. We've lost connections between habitat protection needs, between SIA, between DFO, Environment Canada, and NWPA. We've lost habitat protection offices and staff. There's no habitat enforcement, despite what the DFO bureaucrats and the past ministers have said. We have next to no public review in terms of environmental assessments. Delegation of key habitat protection has been delegated to industry and self-compliance and to the federal harbors, and now we put the wolf really in charge of the sheep. That's where we sit in Canada. And there's a lack of connection of fish to the overall ecosystem health. Go to DFO, we'll see now they have an ecosystem management branch. That means nothing. We're doing less ecosystem work now than we probably ever have in the past, and the laws and the agencies are fragmented so much we can't bring the ecosystem together. Recommendations that I would make: restore Section 35 to the Act to more or less be worded as it was in the past. That was a giant step forward to protect habitat in Canada, and that was basically neutered or butchered by the past government. We should retain generally the definition of what is fish habitat in Canada. We should eliminate the 2012 provision that it's illegal to permanently or seriously harm fish habitat as exposed to a commercial, aboriginal, or recreation fishery. Recommendation 4, fish habitat law now should relate to any waterway in Canada that supports fish or a fishery, not just a fishery exposed to a type of a fishery. Any significant harmful alteration, destruction of habitat must be subject to a proper environmental assessment under SIA. It must be meaningful, transparent, and allow maximum public input. That's not the case right now. Recommendation 6, we should develop a habitat violation ticket system for lower level violations and retain the general provisions for major offenses. 7, we have to restore reasonable resources and scientific capability to DFO. That's so essential. We've had a terrible recruitment of many managers in the last 12 years. They're not there to do the job. They were there to basically play political football, and the present minister has to get over that problem somehow. And a lot of key people that had a lot of experience were basically laid off, and the agency has to dig itself out of the hole. We have to have a proper and effective enforcement program. We have next to nothing. In my brief on page 8, I indicated a graph of where enforcement investigations have gone in Canada. They've gone right downhill from about 1,800 in 2002 to about 300 in 2010, and they're almost now at zero, especially when it comes to prosecutions. I think in 1998 we had 48 convictions in Canada under habitat law. 2008 we had 1. 2015 we had 0. I mean, if that doesn't indicate a problem, we've got a real problem in our hands. We have to recognize DFO as being separate from fish farming. I think fish farming should be given to another ministry like agriculture. DFO is still in a great conflict of interest where they promote fish farming and pretend they also protect habitat. And the last comment I'll make, and I'll close, is that I know you'll be meeting with DFO civil servants and as high levels as deputy ministers. And in the 33 years I've worked with DFO, things were good in the first several years. It was almost, and I hate to use the word, the golden years, but people had the will, they did the job, and I think they were quite honest. Now we find politically inspired staff at very high levels in the agency, including the regional offices. And I think there's a tremendous lack of honesty in DFO, and the public has no trust for them at all. And I think all you have to do is look at some of the material they produce on the internet that's available to all Canadians. And we look at page 4 in this document, Projects Near Water. It talks about how the amendments to the Fishery Act in 2012 brought everything together and consolidated it. Well, the exact opposite has happened. Now pollution is looked after by Environment Canada. Serious offences are looked after by DFO. Agriculture is looked after by another part of DFO. If it involves any nuclear facility, the Canadian Nuclear Safety Agency handles the Fisheries Act. If it involves an energy project, the National Energy Board looks after the Fisheries Act. And certain provinces like New Brunswick, Nova Scotia, and Prince Edward Island look after the Federal Fisheries Act. We've delegated habitat protection to the national harbours, 17 of them in Canada. And how can the bureaucrats say we've consolidated it and brought it together with the harbour changes? The exact opposite's happening. In my experience in government is when we pretend we've brought it all together, we've said this, you could be probably 90% certain we're going in the opposite direction. That's what's happening right now. Thank you.
Thank you, Mr. Langer, for that. Now we go to Ms. Nolan from the West Coast Environmental Law. Thank you very much. For 10 minutes, please.
Thank you for the opportunity to speak here today, and it's a pleasure to be here with Mr. Langer, who I've known for many years. My name is Linda Nowlin, and I'm a staff lawyer with West Coast Environmental Law in Vancouver. As an example of the type of work I do for the organization that's been here for more than 40 years, I haven't been with it for 40 years, though. I've given a dozen workshops around the province on fish habitat protection law for community and streamkeeper groups. We've prepared 2 briefs. The first is Scaling Up the Fisheries Act, Restoring Lost Protections and Introducing Modern Safeguards. And the key messages from this brief were endorsed by over 45 groups, and I sent a copy to each of you earlier this year. The second one, a new one, is Habitat 2.0, a new approach to Canada's Fisheries Act, presented jointly by West Coast Environmental Law and FLO Canada. FLO is the Forum for Leadership on Water, and I'm pleased that Tony Maas is here today from FLO. A summary of a review we commissioned on international best practices on fish habitat is included as an appendix to our new brief. I'm going to review the 6 recommendations in Habitat 2.0, but first I'm going to do a bit on background. In 1977, former Fisheries and Environment Minister Romeo Leblanc introduced a fish habitat regime into Parliament, and he explained why he was doing that. Quote, "The chain of life extending to the whole open ocean depends on bogs, marshes, mudflats, and other useless-looking places that ruin your shoes. Biologists have likened these areas to the cornfields and wheat fields of the ocean." He urged Parliament to protect the irreplaceable nurseries of fisheries well-being, and these words ring true today. All parties supported that bill and urged the minister to give it swift passage, which it did receive. Fish and their habitat need help even more than ever today, so the government's commitments to restore the lost protections and introduce modern safeguards are very welcome. Both our briefs address both topics. The Committee on the Status of Endangered Wildlife in Canada, COSEWIC, ranks freshwater and marine fishes very high on the danger list. In fact, the chair of COSEWIC says that they're the second, as a group, the second most endangered group of species in Canada. And he also says the leading cause of risk for most of these freshwater fishes is habitat loss and degradation. The numbers get worse every year. and the numbers of fish at risk have increased since the amendments. I have other examples of fish decline after the 2012 legal amendments, which I'd be happy to address in questions. As more background, I'd like to draw the committee's attention to the words of the Supreme Court of Canada, who in 1992 emphasized that environmental protection was one of the major challenges of our time. In 1977, the same court said, 1997 said that this was a public purpose of superordinate importance. That decision referred favorably to the need for national environmental standards. And that's what Parliament intended. Parliament saw fit in the Constitution to give exclusive legislative authority over seacoast and inland fisheries as one of the great questions which affect the general interests of the Confederacy as a whole to the National Parliament. And those are the words of John A. Macdonald, stated during the debates on Confederation of the Canadian Parliament in 1865. The 1868 Fisheries Act included provisions to protect fish habitat, not just fisheries. And our brief contains a number of examples from published legal cases across the country that show why we need strong habitat protection to deter harmful activities that damage fish habitat and destroy it and alter it, sometimes temporarily. Fish habitat protection is not only a national concern, it's an international legal obligation, another reason why we need national standards that only the federal government can promote. I won't go into the full range of treaties that spell out this obligation. Some are in the brief. There is wide agreement that the 2012 amendments weakened habitat protection in the Fisheries Act. Weakened, not eliminated. Perhaps the best summary of how the amendments were viewed came from Mr. Justice Cohen, who conducted a 3-year judicial inquiry into the cause of low sockeye return of 2009 to the Fraser River. I'd be happy to say more about the Cohen Commission's findings and Mr. Justice Cohen's findings and questions. There are 2 ways in which the current Act is not an effective legal tool to protect fish habitat. First, the sole court case I could find interpreting the new standard finds it weak. Again, happy to talk more about that in questions. Second, and Mr. Langer touched on this, enforcement is not occurring. It appears there has not been a single charge laid related to a violation of the new Section 35 since the amendments came into force in November 2013. And that's from information from the DFO annual reports to Parliament for over the past 2 years. The reason for the lack of the charges is unclear, but many experts believe that it's due to the uncertainty of the meaning of the new statutory language, that if you don't know what it means, you're not going to go lay a charge about it. In contrast, in 2001 and 2, 54 charges were laid, and I have more numbers if you want them. Contrast this record with recent convictions and fines levied against offenders for violating the prohibition on depositing deleterious substances into fish-bearing waters. Last year, 92 charges were laid under that provision, with a further 28 laid for violation of the metal mining effluent regulations. One guilty plea resulted in the largest environmental fine in Canada, $7.5 million from a Quebec mine operator. Prosecutions are an essential part of the regulatory toolbox. If we don't have any, there's a problem. And clear language in the law is needed for successful prosecutions. Now I will go through our 6 recommendations quickly and focusing on the first 4. The first is to restore the prohibition on had, and you've heard most witnesses recommend that. Restoring these terms will provide guidance due to the existence of 40 years of judicial interpretation of those terms. But a new had section can also modernize the Act, and we recommend that if had is reinstated by Parliament, it includes new features, incorporating relevant sections from DFO's numerous policies, unenforceable policies on habitat protection, directly into the Act would help fill the legislative vacuum noted by leading marine law expert Professor David van der Zweig. We could have an expanded and modern definition of fish habitat in the Act. We could put factors into the Act which must be considered when authorizing had. For example, how important is the habitat? Is the impacted habitat type in low supply or of high value or both to fish production? Secondly, the Act must protect key elements of fish habitat, including environmental flows. The Fisheries Act should provide a legally binding national flow standard to conserve the quantity, timing, and quality of water flows, also known as environmental flows. CSAS scientists point to this issue as a deficiency in the current regime and say a national standard is needed. So the Act should define conditions of flow alteration that constitute HAD based on science advice from CSAS, that's the Canadian Science Advisory Secretariat used by DFO, and our brief contains more information on that. These are key changes, and if enacted, will demonstrate the government's commitment to modernize the Act. Our third recommendation is to protect key areas of fish habitat. The new Act contains a mechanism to designate ecologically significant areas by regulations. Unfortunately, this provision has not yet been used. It's a good provision. We recommend that it be used. For example, eelgrass beds of particular significance could be designated as essential fish habitat and therefore off limits to development. Flora Bank at the mouth of the Skeena River is an example of this type of habitat. Happy to talk more about that in questions as well. Various DFO policies indicate that some habitat areas should be off limits to development, such as, for example, the 2 wild salmon policies on either coast, the policy for managing the impacts of fishing on sensitive benthic areas, and the policy on cold water corals and sponges. Another potential no-go zone is limited and imperiled spawning habitat for marine shore spawning forage fishes, such as surf, smelt, capelin, and Pacific sand lance. For example, in Washington State, such beach habitats are listed and protected as critical wild salmon habitat. Our fourth recommendation is to protect fish habitat from key activities that can damage habitat, such as destructive fishing practices and the cumulative effect of multiple activities. We adopt Dr. Fuller's evidence to this committee on the first point, and on the second point, cumulatively, minor works are considered to pose the greatest threat to fish habitat. To ensure that the cumulative impact of minor works and activities are understood and considered, we recommend, as have other witnesses, that the Act require the creation of an accessible database so DFO knows what's going on out there with cumulative impacts and then can take more steps. And agree with Mr. Langer that for the Minister to fully fulfill his mandate to restore lost protections, environmental assessment triggering needs to be restored to the Canadian Environmental Assessment Act. Our fifth recommendation is to protect fish habitat from key threats, such as a changing climate. And our sixth is to modernize the governance of fish habitat. Specific provisions on co-governance and co-management of fisheries must be developed collaboratively with First Nations. This limited committee consultation process is not the appropriate forum to do those provisions, to develop them. That must be done through a nation-to-nation consultation process. In conclusion, a new approach to habitat, Habitat 2.0, will ensure healthy fisheries for generations to come, the overall goal for the mandate in the mandate letter given to him by the Prime Minister. Implementing these 6 recommendations will help achieve that goal. I will end, as I started, with words of wisdom from the former Fisheries Minister in 1977, the Honourable Romeo Leblanc. If our laws can protect the water, if we give the fish a place to live, we can have a better place for man and woman to live. The work of constant monitoring and restraint, where necessary, is hard, but the alternative prospect of forever losing stocks or species of fish is not acceptable. The fish and their waters are a public resource. With the changes to the Fisheries Act that I am asking for, my department will be better able to carry out the public responsibility of guarding them. Thank you.
Thank you, Ms. Nowlin, for that. And now we go to questions and comments. First, we're going to go to the government side. Mr. Hardy, for 7 minutes, please.
Well, thank you, Mr. Chair, and thank you to the witnesses. Mr. Langer has already answered the question in his testimony, so I'll ask Ms. Nowland. That Cohen recommendation that aquaculture be separated from the DFO's mandate, do you agree with that?
Yes, I do agree with that.
Why?
I think it is a conflict of interest for the government to be promoting that activity at the same time as fulfilling their overall mandate to conserve fish and fisheries.
We heard a few days ago in testimony a very specific example of where, in one case, a nuclear power plant had been given permission to put warm water back into a stream, and that led to a very measurable mortality rate on the fish in that stream or river. Are there other permissions that you're aware of that should be perhaps at least reviewed in the context of modernizing the Act?
Yes, well, one recent example that I'll give is the approval of the Pacific Northwest LNG project up in the Skeena River. That's Flora Bank that I referred to. Back in 1972, DFO said this was one of the most important habitat areas on the whole Pacific coast. So it was surprising to see that DFO thought now, with the new definition under the Act, that the amount of serious harm to fish habitat using the new definition was acceptable. Many independent scientists disagree, and I think that authorization could be one that could be reviewed. It's tens of thousands of square meters of habitat that are going to be put at risk from this recently approved project.
Mr. Langer, you referred to a jet fuel facility near the Vancouver airport that had been approved by the Vancouver Port Authority, basically under permissions delegated from the federal government. In my discussions with the Prince Rupert Port Authority, it seems that the siting of the Northwest LNG plant also resulted from a decision by the Port Authority. Can you comment basically on the wisdom of these delegations? Are the Port Authorities really in a good position to make the best possible choices for all of the interests involved in something like this?
I would say they are definitely not the proper authority to be making decisions on behalf of what's good for fish. Their business line is the export and imports of goods, and the calling above anything else is to make a profit, even though it's a federal agency. And that's the same with private industry. Business only exists to make money. That's their primary objective. They don't make money, they don't exist any longer. And how can those agencies put fish high on their agenda when their agenda has many other callings? We have a fishery agency. They have the expertise. Now we have Port Vancouver hiring fisheries biologists and duplicating what another federal agency is doing. But their goal is not to conserve and protect habitat. Their goal is to develop maximum port development. And I would say I can't see how any government could have allowed that conflict of interest to occur. And I guess it would apply to all 17 federal harbor authorities in Canada, just that in British Columbia, the Prince Rupert one and the Vancouver one creates the largest environmental conflicts right now, with probably about 10 projects proposed to Fraser River Estuary. Environment Canada, DFO largely disappeared, and Ports Canada and the Prince Rupert Port Authority is determining what's adequate for habitat compensation, where it could be built, and how did we ever get in that mess? It's truly putting the wolf in charge of the sheep. There's something really wrong there.
Do I have additional time?
Oh, good. 3 minutes.
When we look back at the reason why the changes were made, about 5 or so years ago, the federal government of the day was very interested in, giving a boost to the economy by getting many public works done, and there was a concern that was expressed by many rural municipalities about what they saw as the onerous red tape that added time and money to the cost of doing these public works. And I guess the question is, if we're looking at modernizing the Act, if we were to preserve a system that allowed public works to go forward, in a more expeditious and less costly way, what will that take? Will that take a streamlining of the regs if we were to reintroduce many of the the foundational protections that you say were taken away? Do we go back to them and try and fix them up, or is it a matter of just simply more resources for the DFO to go in and do the kind of inspections and analysis, or is it a combination of the two? I'll ask you both to respond to that.
It's not a simple solution, and of course DFO will need some additional resources, but when I was a DFO employee, I'd said, we can't hire enough biologists so one can sit on every bulldozer in Canada. Common sense has to apply, and you have to streamline many things. The bureaucracies are not good in streamlining things and cutting out a lot of red tape, so that direction has to be there. What was the other part of the question, sorry?
Well, just basically, you know, is it a matter of trying to make an assessment process work better and faster? Is it that, or does the DFO just simply need more resources to get things done in a reasonable amount of time?
Well, I think you have to centralize expertise in the right agency. When we're dealing with an energy issue, the National Energy Board should just be referring to that energy issue. Do we have enough natural gas for future generations? Do we build a pipeline across provincial boundaries? But why would the National Energy Board then determine what's good for fish on every stream that pipeline crosses? That makes no sense at all. So get all the agencies to do their job and do their job properly and do it efficiently, versus now we have a fragmentation. As I mentioned, when it comes to the Fisheries Act, we probably have 12 different groups across Canada looking at the Fisheries Act and applying it. And that's the exact opposite of what the pipeline industry asked for. When I was with DFO in about the year 2000, they complained and whined a lot and had a lot to do with the butchering of the Fisheries Act. They said when we're in BC, we have to tunnel under a river to protect salmon. We go to Alberta, we can just rip through the river, an open trench. Why is there this difference? And they went to Ottawa and complained, we want one approach. Well, after 2012, it appears we have more different approaches than ever. Is that efficiency? That's going to be costly. It's going to create a lot of confusion, including confusion in the courts in terms of who's really in charge. So, and then there's this myth that the Fisheries Act slowed down the economy. Well, when Habitat came into the Fisheries Act, the economy kept growing and growing. I didn't see any decrease in the economy anywhere. So I think there's a bit of a myth there that we had to get rid of the Fisheries Act. That certainly didn't occur at all. And it's just that, yes, it can be done more efficiently. When we look at DFO resources right now, well, they've been really chopped since 2012. Yes, they'll need some additional resources, but even more so expertise. And as I mentioned, they need a better organization. And they need more expertise in management. Some of the management DFO leaves a lot of doubts in my mind.
Thank you, Mr. Langer. For 7 minutes, Mr. Sopa.
Thank you. I was a little shocked, Mr. Langer, at your initial at your brief when you talked about, I think you used the word the upper management of DFO. I think you used the word was not honest. I find the senior staff of DFO, both when I was on the government side and on this side, to be very forthright and very scientifically literate, and I certainly enjoy having them before this committee. In terms of the habitat section, let's be very, very clear. There is a habitat protection section that remained in the new Act. And it says, serious harm to fish is defined as death of fish or the permanent alteration to or destruction of fish habitat. And then it went on to a definition of fish habitat. So it gets a little tiresome to hear that there are no habitat protections under the new Fisheries Act, which is clearly not the case. We had a delegation from the Mining Association of Canada, people that actually have to deal with these acts. And in their view, in the mining industry experience, the 2012 changes to the Fisheries Act have in practice broadened the circumstances in which the Section 35 prohibitions apply and increased the circumstances in which an authorization and offsets are required. And then they went on to say the amendments have encouraged greater attention to sound science and the purposes of the Act. Just a simple yes or no. Have either of you worked in industry? And I'm thinking of like for a mining company, a forestry company, or anything like that.
Have I ever worked in?
Have either of you worked in the natural resources industry, specifically for a mining company, a forestry company, a potash company, anything like that?
No, I've not worked for a mining company, but I did work for Shell Oil in the Alberta tar sands, so that's getting pretty close to mining.
Ms. Nolan, have you ever worked in industry?
As a lawyer, and when I first started, I represented engineering and architecture firms for large construction projects. And in my current work as an environmental lawyer, streamkeeper groups
The reason I asked
excuse me, I haven't finished. Streamkeeper groups are very concerned
I'm
about
afraid this
how
is my
the law
time
works.
as a member of Parliament.
Excuse me, Mr. Chair. Do I have time to finish my question or not?
And we just pause right here.
We only have 7 minutes.
Ma'am, to be honest, we do have 7 minutes each person. I apologize if you feel you're inconvenienced. I know, but it's up to our members here to use their time as they wish. I'll again point of order. Yes, Mr. Donnelly.
If the witnesses are being asked a question, they should be allowed to answer the question.
Yes, I realize that, Mr. Donnelly, but keep in mind that the 7 minutes belongs to you as a member. If you want, you can proceed as you see fit. If someone feels that is rude behavior, then I apologize, but it still belongs to the member at the end of the day, which I have to uphold. So, that being said, I'm going to return to the clock. Ms. Nolan, would you go ahead?
Over to you.
The reason I asked that is I've had the pleasure of working for a forest company, directly for a forest company, not representing them, not being a consultant to them, working for a forest company where I ran a wastewater treatment plant and the environment programs. And one of the things that environmental activists never give industry credit for is the fact best management practices are implemented at all times in every industry. And I know, Mr. Langer, you kind of talked down about the business of making money. The fact is, big business and industry and natural resources companies use that money to improve environmental standards all the time. One only needs to look at Sudbury, the air quality improvements there, and the wastewater treatment plants in all forest companies now. Mr. Langer, you made a point. You said there's been a rapid net loss of habitat. Can you give me some specific examples with numbers attached under the new Act?
Well, we just have to look at the Petronas LNG project in the Skeena River estuary. It's a relatively pristine estuary. We've learned from the Fraser River, the Squamish estuary, and many others, that's not a place where you put industry. You have to site in an alternate location. No one in DFO is against industry and the economy, and 80% of the solution at times is placing the right industry in the right location. So here we've approved a project in the middle of a virgin estuary. That's a tremendous setback. In the Fraser River, DFO seems to have disappeared, and we're allowing super tankers of jet fuel to come up into the Fraser River estuary, turn around in a narrow waterway, build a giant terminal for 80 million liters of jet fuel. That was rejected in 1988, but it's approved now. This goes on and on.
Interestingly, that you both used the Fraser as an example. Ms. Nolan, your example stopped in 2009, which was admittedly a very full, low year. But wonder of wonders, in 2010, the sockeye sprang back, and in 2014, there was a record sockeye salmon run of 20 million fish. So I think it's important to complete the story here. So it's obvious that the Fraser River system is currently capable of producing millions of fish, even under the new Fisheries Act, and perhaps even because of the new Fisheries Act. I found it interesting, when we changed the Fisheries Act, we focused on production of fish. Like, fish production is quite important. So I want to ask you a question, Mr. Langer. In Prairie Canada, a number of reservoirs have been built over the last 40, 50 years, and there's something that you're familiar with as a biologist called the reservoir effect, in that the fish population, the fish production just boomed dramatically to the great benefit of local communities. So were the building of those reservoirs and the admitted changes in fish habitat, which caused an incredible boom in fish production, was that good or bad for fish?
Well, I'm not aware that reservoirs have created a great boom in fisheries. Generally, downstream areas are affected greatly by reduced flows or altered flows. We just have to look at the Nechako River and the Kenny Dam that was built there and the damage that is done, including the temperature. I don't know where you get your information from, but probably one of the greatest impacts to fishery runs in Canada and the world is the building of dams and reservoirs. Certain fish can be introduced into a reservoir and they will do well there, but that does not include the salmon that have to spawn in that area and get flooded out and get blocked by the dam.
I'd like to bring you to my constituency to see the Lake of the Prairies reservoir and the significant walleye fishery that has developed because of that reservoir. Ms. Nolan, one thing I find consistent among the environmental activist groups is the desire to reduce the ability of the minister to decide public policy. The World Wildlife Fund said that before us. The Ecology Action Center said that for us. And on page 5 of your brief, you said limit the minister's regulatory powers. What is it about environmental activist groups that basically want to remove the powers of elected officials to make decisions on behalf of citizens who vote? To me, that's a recommendation against democracy. Can you explain that?
Yes, I'd be happy to. And I'll refer to the Supreme Court of Canada, and I'll quote from them. Though discretionary decisions will generally be given considerable respect, That discretion must be exercised in accordance with the boundaries imposed in the statute, the principles of the rule of law, the principles of administrative law, the fundamental values of Canadian society, and the principles of the Charter. In the Ahuzit case from 2014, when the then Minister of the Fisheries and Oceans wrote a handwritten note beside the science advice from her advisors, who advised not to reopen a herring fishery, she wrote beside it that it should be reopened and gave direction to do so. The judge in that case in federal court admonished the minister for, quote, fudging the numbers, and said, "It seems to me once the minister and the DFO depart from science-based assessments, the integrity of the fisheries management system is harmed." There is never absolute discretion for elected officials. That is a misunderstanding of the law.
All right. That's enough. Sorry, Mr. Sopak. I have to call this to an end.
Thank you.
Now, we're going to go to Mr. Donnelly for your 7 minutes, please.
Thank you, Mr. Chair. And I would like to start off by just mentioning I think we have two Canadian heroes in front of us here in their respective fields. Certainly, they are both heroes of mine. And a quick note, in 2000, I dedicated my second swim the length of the Fraser River to Mr. Otto Langer for his years of dedication to salmon, the salmon fishery habitat, and to the Fraser River. So I'm very happy that both of you are in front of us today in this committee talking about the Fisheries Act. And Mr. Langer, if I could start with you on the recent changes, 2012 and 13 changes to the Fisheries Act. With respect to habitat protection, in your view, was this a good thing?
No, there shouldn't be, I think, any doubt in the minds of anyone that's objective that this was a good thing. We probably lost the basis of protecting 80% of habitat in Canada. We've all heard of death by 1,000 cuts. Well, that's what destroys habitat in most places. And in my last few years in DFO, I did a lot of work on assessment of the no-let-loss policy. And generally, when it comes to the bigger projects, you have a greater industrial will in the company to look good, and they hire better consultants, and they do a better job of assuring a no-net loss of habitat. And government rides them more so because they are a big corporation. But when you take the 101 little landowners in that same watershed, one who's cutting down some trees, destroying the riparian zone, someone who runs across the stream with his ATV, you add all of those up and they're going to do a lot more damage to the stream than one larger industrial development. So, and basically we've deleted out all of that protection from the Fisheries Act. Now that is your harmful alteration, destruction of fish habitat. None of that would be considered serious harm as defined in 2012-2013.
Can you tell me a little bit about your background, why you're qualified to talk about this, how long you've been a fisheries biologist, and for the department, when you were working for the department, et cetera?
Well, I started working for the Department of Fisheries Oceans in 1969. I was recruited out of the University of Alberta with 2 degrees in fisheries biology. I was hired to be a fish protection biologist, and I soon learned that it was hard to do the job unless we had a law, so some of us pushed for a law to protect fish habitat. In theory, we could protect fish habitat from dams, flows from dams, debris from logging, things like that, but there was nothing there to really protect habitat. You could destroy a wetland, you could run a tank through a marsh, and there was nothing to do about that. And we also used the pollution law to protect a lot of habitat. If you did fill in an estuary, we call that a deleterious substance, and we try to protect the Fisheries Act using water quality law. So over the years, I became, in Canada, probably the expert witness that has done more expert witness courses on pollution and the Fisheries Act, well over 100 cases from Newfoundland to Vancouver Island, from the Arctic down to the 49th parallel. And I've been in a lot of tribunals. I've done a lot of work. I've directed a lot of projects, and many of them have been published. And I'm still doing some of that work, including some of the few of the key ones I have right in front of me here that appeared in qualified journals.
Thank you. And Ms. Nowlin, You mentioned in your testimony, you talked about a weak interpretation, and I'm wondering if you could, if you recall that, and if you could expand a little bit more about that judge that talked about the interpretation being of the new act for protecting habitat being weak.
Yes, I'd be happy to. Thank you. The only case I could find that did interpret that section was a federal court case where the Mikisew Cree First Nation objected to Bill C-38, the omnibus budget bill, which weakened habitat protection, on the basis that they weren't consulted. And they were successful, but as the bill had already become law, there was no remedy for them, unfortunately. And in that case, commenting on the impact on their Aboriginal rights to fish, and the duty not to cause serious harm to fish, the new provision in the Act, the federal court said that the amendments to the Fisheries Act removed the protection to fish habitat from Section 35(1) of the Act. And that they also said that the amendment, quote, clearly increases the risk of harm to fish.
Thank you, and you've given clear recommendations. You've submitted them to this committee. Both of you have submitted your recommendations, which I think is really important, and thank you for doing that. In terms of, you mentioned also linking policies to the Fisheries Act, and I'm wondering specifically about the wild salmon policy. If you could talk a little bit more, and if Mr. Langer could also comment about how seeing the linkage of, for instance, an existing policy that the department has, and how that would link better or legally to the Fisheries Act.
Sure, I'd be happy to. So as you know, the Cohen Commission did recommend full implementation of the wild salmon policy and said it was an excellent policy. The only problem was that it hadn't been implemented fully, which is a big problem. It's a stepped approach. So the first step in Strategy 1 is to identify conservation units for salmon, and then you color code them, green, yellow, or red. The red-coded conservation units, particular units of habitat, are supposed to, if you go all the way through the strategy, result in a management change. But unfortunately, that management change isn't well defined in the policy, and even more unfortunately, in the 11 years that we've had the wild salmon policy, we've never managed to get from Strategy 1 to Strategy 4, except in one limited case of Chinook on the south coast. So I think that the Act could be amended to actually talk about how to classify habitat and to require that there is a response when you have red-coded conservation to bring back the fish.
Is there anything you can add, Mr. Langer, on that?
It's probably on this point that I would disagree a little bit. My experience shows that the more complicated your legislation is, the more confusing it is to the courts, and all you have to do is confuse a judge and you can't do any enforcement work. You take the BC Environmental Assessment Act. Recently, we challenged that in the BC Supreme Court, and our lawyers just couldn't understand the Act. They spent days trying to understand the Act and its regulations, and you want to avoid that. I think policy should remain as policy, and it defines simple, strong law. Then you have guidelines of how to achieve that policy. And then, and this is what's lacking, you need a strong industrial and citizen stewardship program where you work with industry and you hold their hand in partnership, and they will learn how to do the right thing to
Thank
avoid.
you, Mr. Langer. I have to cut it right there. Sorry, time is out, and we're going to go over here to Mr. Finnegan for 7 minutes, please.
Thank you so much, and thank you to the panel for appearing in front of us today and giving us your expert opinion and your, I guess, lifelong experience with the protection of fish habitat. I might start with Mrs. Nolan. Could you please complete your statement that you wanted to complete when Mr. Sopak didn't want you to finish? I guess could you please complete what your background, if you have worked in industry, or can you?
Yeah. Well, I just was pointing out that as a lawyer representing engineers and architects for large construction projects, I did have to deal with interpretation of the Fisheries Act, but also now for conservation groups and streamkeeper groups and individual members of the public who call our office because they're concerned about the impact of a development or project on their favorite local stream that they've spent countless volunteers' hours protecting. we have to interpret the Act and tell them how to enforce it. It is definitely true that DFO needs more resources, more enforcement officers, but the law needs to be clarified too.
Thank you. Mr. Langer, if I can quote you here, you said that the biggest setback to conservation law in Canada in half a century, and have watched a steady decline in the application and enforcement of the Fishery Act over the last decade. So, in your view, how?
Hear you. Could you speak up?
Are we good?
Okay. You can please get closer to the microphone.
So,
thank you.
Let me just roll up here. Sorry about that, Mr. Langer. So, if I can quote you, you have described the changes to the Fishery Act as the biggest setback in conservation law in Canada in half a century, and that you have watched a steady decline in the application and enforcement of the Fishery Act over the past decade. So, in your view, what's caused that steady decline in the application? Is it government bending to lobbyists, or is it to save money? What, in your view, why did we go down that path? Why are we kind of cutting back on the enforcement?
Well, I'd say the downhill slide started during the government previous to the Harper government, and that government was, Paul Martin was into balancing the books big time, and cuts were being made in DFO. I think we lost 40% of our scientists then, and we came up with a term called smart regulations. I shouldn't say we, it was imposed upon the agency, I think, and the key thing was self-compliance. Let industry look after themselves, and they'll do the right thing. And experience in Australia, elsewhere in the 50 years I've been around, that simply does not work. So we were going off in the wrong direction, hoping it would work. It was wishful thinking. It hasn't worked. So that was going in the wrong direction. And then the word was out to cut down on enforcement. I don't know why that happened. As I showed in the figure I've given from the Cohen Commission, less and less work is being done every year. I could get into a long story why that happened, but fishery officers were taken off of habitat. That was a really poor move. And we could probably look at 10 different things of why things were going downhill. And then suddenly, in 2012, we decided, well, fisheries aren't doing enforcement work. Let's get rid of enforcement staff. Let's get rid of the habitat section of the Fisheries Act. Let's put them in place. And this is what the pipeline companies now did lobby for. It was a downward spiral since about the year 2000.
Thank you. So Ms. Nolan, you said earlier that the aquaculture industry should be separate from the FO, and so I would expect maybe with Department of Agriculture or some other. So how would that be different? Right now, if it was under a separate department, would they be infringing the laws or the Act as they operate? Can you elaborate on that?
Well, there's some new aquaculture activity regulations under the Act which allow pesticides to be used in water that many believe should be changed. I think I'll leave the questions on aquaculture separation. I'll just refer back to the Cohen Commission report. After 3 years of detailed investigation, I think his recommendations should be followed. He heard from, I don't know, 100 witnesses and commissioned numerous technical studies, and I would rely on his report.
Thank you. In the Fishery Act, that does not include any obligation to restore depleted fish stock to prevent overfishing or reduce bycatch. So in your opinion, and I could ask both of you, does DFO adequately address these issues as part of its suit to fishery-related policies? And please elaborate.
You should start first.
Okay. I think that putting an explicit provision in the Act that requires rebuilding depleted stocks like they do in the U.S. Would be a good idea. It has proved to be quite successful in the U.S. since that change was made to their law. And also a simple prohibition on overfishing would be a good addition, a modern addition to our Act. Why not state the obvious?
Yeah, I think we are, I'll use the word, too liberal in how we run a fishery. And for instance, we can look at white sturgeon, an endangered species in Lower Fraser, and we still run a multi-million-dollar fishery on that stock. and we just say, oh, you can catch and release. Well, is that the way we should protect something that's endangered? And we do a lot of those types of things in government, or we did, and we still do, to basically keep the public happy so they can fish. And at times you do have to reduce fisheries quite drastically. The fisheries people will say, well, you can't do that. You're going to lose public trust. You've got to let them keep fishing. Well, that just doesn't make sense. And we seem to put more money at times into endangered species under SARA than we do to maintain healthy fish stocks. That's truly unfortunate.
So should that be enshrined in the Act, do you think, or how should that be?
Well, I think it's beyond the capability of a human organization to be directed to restore all stocks to a healthy status, unless the United Nations and everyone else is going to get together and reduce global warming, and we do this, and we do 10 times the research we do. It's good to have it, but at times it'll be unachievable, unfortunately. We are into a bit of a downward spiral, and with global warming and many other pressures on the resource, that's probably going to continue, sadly so.
Is there room for aquaculture in the ocean? Do you think there's ways that we can safely practice aquaculture, whether it be open or enclosed cage, recirculating water? Would you have an opinion on that?
Yeah, I was in DFO when aquaculture became a big issue, and then I worked for the David Suzuki Foundation for a few years on aquaculture issues, and I don't think you should have open net cage fish farming. That creates disease problems. We know anytime you put a lot of cattle or fish together, it's almost a disease breeding area, same with humans, and that shouldn't then affect the wild stocks in that area. So you've got to have some containment structure in place.
Thank you, Mr. Langer. I appreciate it. And we have to call it to an end there because we're out of time. Ms. Nowlin, nice to have you with us today, and Mr. Langer as well. We thank you for this. We're going to take a short break and allow our officials. Mr. Donnelly, point of order.
I received a letter on November 21st from Lisa Fong of Aris Fong Lawyers, and she's requesting how the Helsik First Nation can appear as a witness before the committee regarding the Fisheries Act, and the clerk. Yeah, the clerk
Mr. Donnelly,
advised.
We've already been through this, where you yourself can provide the names for people to appear as witnesses. We've done this already. I'm not quite sure if this is a point of order, however. It's a point of contention, perhaps, but nevertheless, I think we were given...
I was seeking clarification then, Mr. Chair, because the last part is that the clerk has done exactly what you're saying, which is advised them to seek out an individual member and ask, and I'm wondering how I should respond to them, given where we're already at, and they're not on the list.
Why don't we just call this to a close, and then we'll talk to the clerk to fix this situation, okay?
Thank you.
Thank you. Oh, back in a few minutes.
Oh, point of order? Mr.
Sure.
Chair? I'd like to propose a motion for the committee here in light of all the testimony and the desire for the testimony.
Mr. Arnold, have you given us the 48 hours notice as required?
No, I didn't believe I needed a motion just to provide a motion for the committee.
Motion related to business before the committee as of right now.
Yes.
Proceed.
I'd like to move that the committee request from the Department of Fisheries and Oceans, DFO, all input received from DFO's online public consultation related to the Fisheries Act review to date, that this public input be provided to the committee within 7 days of passing this motion, and that all input received from this consultation be also provided to the committee within 7 days of receipt by the department.
Deeming it fine, do we have any comment from here? Mr. Donnelly, opening up debate.
Just a point of clarification. I think it's a good motion. I'm just wondering about the deadline for input is November 30th, I believe. So if there's some clarification, could maybe Mr. Arnold could speak to that if he is thinking it would be now as opposed to the...
Sure, Mr. Arnold, go ahead.
I just want to get this moved forward as soon as possible, because I'm sure there's a huge volume of that information, and I would hate for it to be provided at a late minute in our deliberation.
Mr. Doherty?
Mr. Chair, I believe the deadline is the 25th of this month.
Mr. Hardy.
Is it the intention of this motion that this material be entered as evidence into the hearing?
I'm sorry, I missed for point of clarification before we proceed, the 25th of November is the deadline for Department of Fisheries and Oceans, the Minister's Office. The 30th would be the deadline for submissions for this particular committee, Standing Committee, Fisheries, Oceans. Mr. Arnold.
The motion is clearly to get these submissions to the committee as soon as possible so that we can consider it with due process.
Okay. Any comment on that? Further debate? It's a motion pertaining to business here today. Sorry, Ms. Jordan, go ahead.
Could we have a minute?
Pardon me?
Can we have a minute, just 1 minute?
Well, there's a motion on the floor, ma'am. I can't break. I'm sorry.
Sorry. Thank you.
We have to decide right now through debate. Do you have a comment?
Right? Take 1 minute.
Can we amend it to 30 days? Fine.
Would you like to make an amendment?
Amend it to 30 days? I'd like to make an amendment to make it 30 days instead of 7.
Well, Ms. Jordan, you're going to have to put an amendment on the floor to that effect.
Yep.
I don't know. Ms. Jordan. Ms. Jordan, for the benefit of what you're hoping to do, I am going to suspend for a few moments so that you can discuss.
Thank you.
All right? I wanted to dispense with this early, but since we have some confusion on the floor, if you want to propose your amendment, put it in writing, let's suspend for a few minutes and we'll deal with it right after that. And I'd like to ask our officials to please come forward and as we suspend. Thank you very much. Okay, welcome back, everybody. We are going to go to, as you know, before we get to our witnesses, we're dealing with a motion that is on the floor. Now, Ms. Jordan, I understand that you have an amendment you'd like to move.
I'd like to move that the motion read the same except for with 14 days as opposed to 7. We just want to change it to 14 days.
Just so that I'm clear.
So the
I
motion,
won't read the whole thing, but the middle part says that this public input will be provided to the committee within 7 days of the passing of this motion, and you want to change that 7 to 14.
14.
All right. Any comment? Mr. Arnold.
Yes, thank you, Mr. Chair. I just wonder why wait for another extra week to receive it from the department. The department should have it within a week. I think is a reasonable amount of time to turn it over. It doesn't mean we have to look at it within those 7 days, but we just want to start receiving it as soon as possible.
we're asking we amend.
Ms. Jordan, go ahead.
Sorry, Mr. Chair. We're asking we amend it to 14 days.
Okay. Any more comment? Let's go to a vote. All right. To amend the motion by changing the number 7 to 14 in the motion that was originally put forward. All in favor of the amendment, please put up your hand. 1, 2, 3, 4, 5. All those opposed to the amendment? Abstentions? I declared the amendment successful. Now we must move to the main motion, and it states that the committee requests from the Department of Fisheries and Oceans all input received from DFO's online public consultation related to the Fisheries Act review to date, that this public input be provided to the committee within 14 days of the passing of this motion, and that all input received for this consultation in future will also be provided to the committee 14? Within 14 days of receipt by the departments. All those in favor of the motion, please raise your hand. All those opposed, I declare the motion adopted. That being said, Mr.
Point of order, Mr.
Doherty.
Mr. Chair, when we set out as a committee to undertake this study, it was to be nonpartisan, not politically motivated, obviously, but it was to look at the best way of moving forward. With that said, we also asked that, or suggested that our witness be the same. We had 2 witnesses before us today. One, I would say, may have political, may have been very partisan.
Just so that I'm clear, this is a point of order, is that correct?
This is a point of order.
You sure?
It is. I move that we strike the testimony of Mr. Langer as he has contributed, we believe, to Mr. Donnelly, could be seen as being partisan and politically motivated.
I'm afraid you cannot move that point of order, Mr. Doherty. I don't think that's pertinent to the business at hand. I think this is testimony that we've been agreed on before, and we go through a process to do this.
He has contributed to both the NDP board
I appreciate that, Mr. Doherty, but is there a particular point to this point of order that pertains to the standing orders?
Well, absolutely. We've talked about our being a science-based study, not politically motivated.
Right, but where in the standing orders does it talk about that, is my point. I think I have to rule out your point of order, sir. It doesn't pertain to being a point of order. You can bring it up in debate, you can bring it up the witnesses at the next testimony if you wish to do so.
Okay.
But I just want you to understand that.
Thanks, Mr. Chair.
Thank you. I'm sorry, Mr. Donnelly, do you have a point of order? Or?
Following up, you had mentioned that on the break.
You can do that, yes. You go right ahead. You can bring it up to the clerk if you wish, whenever you wish. Okay? You can do it now if you want.
Oh, okay. Thank you.
No, sorry, Mr. Donnelly. Physically bring it up to the clerk if you so desire.
You're going to hold on?
Yes, I'd like to get on with this meeting. That's the issue. Pardon me?
You're asking me to do it?
Just give it to the clerk, yes. Yeah.
I'm looking for an answer.
Well, hello. Okay, well, thank you for coming. We're here for the next... little while, about 50 minutes or so. So we hopefully, this is for the supplementary Bs, of course. And I want to thank our witnesses for coming. We have Tony Matson, Assistant Deputy Minister, Chief Financial Officer, Kevin Stringer, Associate Deputy Minister, Jody Thomas, of course, who's Commissioner of Canadian Coast Guard, and Mario Peltier, Deputy Commissioner of Operations, also coming to us from the Canadian Coast Guard. So, that being said, you have 10 minutes to start, is that correct? And one person will be doing this, Mr. Stringer?
Oui, et c'est...
Yes. And it's Tony Matson who will be doing that. I just wanted to say that we are very pleased to be here to present and respond to the questions regarding supplementary estimates B. As you know, the minister appeared before the committee last week with the deputy minister and are not available to appear again today. However, our senior officials are here. And if you will allow it, Tony Matson.
Financial officer will do a very short 5-minute presentation on the supplementary B. Thank you very much.
Thank you, Deputy, Mr. Chair, and hello, bonjour to you, committee members. Mon nom est Tony Matson, dirigeant principal.
My name is Tony Matson. I'm the Assistant Deputy Minister and Chief Financial Officers of the Department of Fisheries and Oceans and the Coast Guard, and we're here to give you an overview of the Supplementary Estimates B 2016-2017 for the Department of Fisheries and Oceans.
Of Fisheries and Oceans, and the Commissioner and Deputy Commissioner of the Canadian Coast Guard. I've prepared very brief remarks. This should allow plenty of time to go through any questions that the committee may have. Before I provide a quick synopsis of the financials, I would just offer a simple reference that we are currently in the midst of the second supply period. Section 26 of the Financial Administration Act requires all spending to be approved by Parliament. Supply bills are referred to the committee where the contents are studied before voting actually takes place, hence our presence here today. In these estimates, we are seeking Parliament's approval for a total of $26.5 million. This would bring our approved authorities to date to $2.607 billion, as $2.581 billion had previously been approved by Parliament through the main estimates, supplementary estimates A, and transfers from central votes to our carry-forwards from last year. This funding summary is presented on page 2-31 of the Supplementary Estimates publication, ou à la page 270 pour la version française.
Or on page 270 of the French version.
To summarize, we are seeking $19.9 million in operating expenditures, $1.6 million in capital expenditures, and $5 million in grants and contributions. Budget 2016 provided funding over 5 years starting in 2016-17 to Fisheries and Oceans Canada and Natural Resources Canada to support maritime conservation activities, including the designation of new marine protected areas under the Oceans Act. We are seeking $11.8 million in these supplementary estimates towards achieving our target of protecting 5% of Canada's marine and coastal areas by 2017 and 10% by 2020. This commitment is clearly reflected in the mandate letter of Minister LeBlanc. Budget 2016 also provided funding over 5 years, starting in 2016-17, to 7 federal departments and agencies to adapt to climate change impacts by implementing programming focusing on building the science base to inform decision-making, protecting the health and well-being of Canadians, building resilience in the North and Indigenous communities, and enhancing competitiveness in key economic sectors. We are seeking $2.6 million in these supplementary estimates to continue the work to assess the risks for the department caused by climate change in Canada's 3 oceans and major inland waterways, to fund research to understand the impacts of climate change, and to apply the science to facilitate departmental adaptation to climate change. We are also seeking $3.4 million for the government's review of the Fisheries Act and early action to strengthen monitoring. The outcome of this initiative is to provide Canadians the opportunity to participate in the review of the changes to the Fisheries Act and to support the restoration of loss protections and incorporation of modern safeguards. Pour la garde côtière canadienne, nous cherchons
the Canadian Coast Guard, we're looking for $1.7 million to strengthen the prevention, preparation, and responsiveness to marine incidents in the waters south of the 60th parallel, as well as $1.5 million for the acquisition of 2 new survey ships.
31 of the supplementary estimates publication, ou à la page 270 pour la version
Page 270 of the French version.
technical and routine in nature. This includes accessing royalties from intellectual property for the reprofiling of funding to align financial resources to updated project timelines or to match recipient requirements in the case of grants and contributions. As well, we are seeking a relatively modest number of internal vote transfers that are net neutral to the overall departmental financial base. This is a clear example of sound resource management stewardship where we are seeking your approval to use existing reference levels to meet our program demands by placing the funds into the right bucket. As an example, the department is transferring $600,000 from its operating vote to its grants and contributions vote to support the Anaquotum Resource Management Program to develop a restoration project for Little Southwest Miramichi River, New Brunswick. This will create a habitat bank to offset possible damage incurred by small craft harbor projects that may harm commercial, recreational, or aboriginal fisheries. We also have a small amount of transfers to and from other government departments, which are also net neutral to the overall government financial framework. These are listed on page 2-32 of the publication, ou à la page 271 pour la version française.
Page 271 of the French version.
Get to them. I would like to take this opportunity to thank you for allowing me to compliment Mr. Stringer's opening remarks on our supplementary estimates for this year. My colleagues and I would be happy to entertain any questions you may have. Thank you.
Okay, thank you very much. We're going to start the questioning, and of course we'll start with the 7 minutes. We're going to go to Mr. McDonald, and I believe, are you splitting your time or are you going to share it?
I'm going to share my time with the other Ken and the committee, so it's going to be Ken Square who's going to look after this line of questioning.
We'll start with Ken, end up with Square. Very good. There, carry on.
Thank you, Mr. Chair, and again, thank you to the DFO officials for coming here again today. It's great to see you any day, and the wealth of knowledge that you bring to the committee is very much appreciated. I want to talk firstly about something, and we've been hearing lately misinformed information about not creating any new jobs throughout government. Recently, we had an announcement of the reopening of the Marine Communications Centre in the city of St. John's, which is the capital city of Newfoundland, where my riding is outside of there. But what exactly will that do for the creation of jobs in that particular centre, based on what was there before it was closed up by the previous government to what it will be at with the new level of service?
Thank you for the question. Yes, we'll be reopening the Marine Rescue Sub-Centre that was previously located in St. John's, Newfoundland. We will have 12 watchkeepers, 16 staff total. I believe previously we had 9 watchkeepers. 12 in the old centre. What we're doing is taking the functions that the centre previously did, but we're also adding some capacity. We're going to make the centre an emergency operations centre. It's going to be 24/7 as it previously was. We're also going to combine it with our regional ops centre, which will become 24/7, so that we have eyes on the water 24/7 for search and rescue, but also for environmental response incidents. It's sort of an all hazards approach rather than a pure search and rescue approach. It will have the search and rescue capacity, absolutely, but we're going to give it other duties and maximize the opportunity that we're getting in reopening the centre.
Thank you for that, because I know it's great news for my area, which many people make their living on water. My next question has to do with a program that's been offered in the past for your department, especially to do with small craft harbours, is the divestiture of some of your properties to, whether it be to municipalities or other interested groups. Do you foresee that program continuing, and have you allocated a certain amount of funds to continue with that program?
So thank you for the question. It will continue. It's an important issue. We have 750 core harbors that have been identified, core harbors, and then we have another about 300 yet that are non-core that we are seeking to divest. We've divested over 1,000 over the last number of years, so it's been a substantive effort. There is the overall small craft harbor budget each year, in addition to the additional infrastructure monies that we get, is about $75 million a year. So a certain portion of that we use for divestiture each year. It's usually a small portion because the needs of the ongoing harbors for maintenance, for dredging, et cetera, takes most of it. So it's a small piece of that. And it is an ongoing challenge. We are looking always for local community groups, for municipalities who are interested in taking over responsibility for them. What we will do is make investments in them to make sure that they're ready to be handed over. So we do have some funding. It comes out of our core funding, out of that $75 million, and it's a small piece of it, but we do feel we need to continue to do that.
No, I agree. It's a great program, actually. As the whole municipality where I live, they took over some property. They've got some great plans for it, and it was a great project overall. I'll start to share my time now with the other Ken.
Thank you, Ken. Thank you, Mr. Chair, and thank you, everybody, for being here. Our first study in this committee, of course, was the closure of the Comox base and the consolidation into the Coast Guard base in Sydney. I was pleased to see just the other week the first quarterly report be issued by management at the Sydney base or the facility. Understand that this is kind of a baseline report. They're establishing the baselines to which they will report, in the coming months. There are still some concerns. Concerns continue. We heard from Powell River that there were some issues. I had the opportunity to attend the Sydney facility, and top-notch technology, top-notch staff, a very crowded, noisy room. So I think that there are still some unresolved issues there. The one, though, that I really wanted to ask the Commissioner about is what progress has been made on stakeholder consultation. Are we out talking to the fishers, the mariners, about the quality of the radio reception, the quality of the information they're receiving, and the quality of the response for calls for assistance? Are we engaged in those conversations?
Thank you for the question. And yes, the first quarterly report was posted, and as promised, it is a joint union management effort to look into all of the any technical problems or operational problems with the system. That's going really quite well. Stakeholder consultations, I can't say with fishers absolutely that's occurred, but certainly with all of our large stakeholder groups through our Regional Marine Advisory Board, through our National Marine Advisory Board. We just met with the Western Marine Coalition this afternoon, tug operators, ferry operators, et cetera, sort of the landscape in BC. And we heard feedback from them. They're feeling very positive about the system. And so the answer is yes, we're consulting broadly and want to hear the view from the marine using public.
Well, I would hope that the individual fishers would also be included in that, because they're the ones in the smaller vessels who would be most at risk if they didn't receive timely information that they could understand and obviously act on. Thank you, Mr. Chair.
Okay, and thank you, Mr. Hardy. Now to the opposition for 7 minutes. We're going to start with Mr. Doherty.
Thank you, Mr. Chair. I'll direct my questions to Mr. Matson, Mr. Stringer. Mr. Matson, Mr. Stringer, did DFO do an investigation into the deaths of several thousand fish after the sewage was dumped in the Amaska River?
I don't know the answer to that question.
Okay. Do you have a mandate to do to do an investigation?
After which?
The Amaska River.
Sorry, the dumped.
Do you have a mandate when sewage is dumped into these rivers and there is a death, or there is the deaths of several thousand fish are made aware? Do you have a mandate to do an investigation?
So Section 36, which is the section of the Fisheries Act, is the first piece that is implicated there, and that is a Environment Canada lead. Section 36 is the pollution section. It is the deposit of deleterious substances into fish-bearing waters. So that would be an Environment Canada lead. That said, there is often a habitat impact as well, and we will work with Environment Canada on that.
Is your department aware that there was 50 million litres dumped on Monday, 60 million litres dumped yesterday, projected 18 million litres today, 7 million litres is forecasted to be dumped in the St. Lawrence River, in the St. Lawrence River in December. Are you aware of that?
I'm not aware of that. The department may well be aware of that.
Okay. Again, Mr. Matson, Mr. Stringer, your department deals in scientific fact. When you make decisions like whether to impose a moratorium on cod, what role does public opinion play in making those decisions?
I think when we take a decision on closing a fishery, a moratorium on any fishery, science is the foundation. Science is always the bottom line. When we are talking about getting ready to reopen a fishery, we would consider socioeconomic impacts. We would consider the views of the public. We'd consider other issues. Again, science needs to be at the core and the foundation of all of it. The pillars of decision-making starts with science. Socioeconomic considerations must always be considered as well, but the science and the conservation is always our bottom line.
When you have public opinion, do you separate public opinion by geographic region, by industry group, third-party interests, small businesses, concerned citizens?
When we look at the socioeconomic considerations, and I would say that we don't often look at what does public opinion say on this. What we would generally look at in this type of a decision is, again, starting with the science, but in addition to the science, what are the economic impacts? What are the social impacts? If there is public opinion, we would look at that as well. And you would start with the area that's most impacted, because that's the area where the effects are going to be.
Mr. Stringer, Mr. Matson, we've heard testimony over the course of our studies that we've been doing that are contradictory in terms of the DFO not having the resources to do their job. The DFO is just not doing the job, and you can't trust what DFO management is saying and DFO officials are saying. Is it a matter of, and I'm trying to frame this properly, is it a matter of not having the resources to do the job or choosing not to do the job in terms of your DFO officers?
In terms of?
Officers, enforcement.
Enforcement? Well, we actually, in terms of enforcement writ large, we have a complement of about 600 enforcement officers across the country. Okay. In terms of resources, I'll say two things, because I think you're speaking about the fisheries protection issues. Okay, so we have 600 enforcement officers writ large dealing with fisheries, species at risk, et cetera, right? With respect to fisheries protection, you will always find public servants saying that they could do with more resources, and I'll be one of those. Okay, I think the minister spoke to this at his appearance. There were reductions at the same time as about the same time as the Fisheries Act changes came into effect. The overall complement in the Fisheries Protection Program went from 450 to 280. Okay. And there were also reductions in enforcement, particularly in what we call Central and Arctic areas, but in areas away from the coast. So the minister spoke to that, so there have been reductions in those areas. Public servants will always carry out the legislation, and this is certainly the case in this program, okay, to the best of their ability, developing policy and programs to be able to address it, to make sure that we are meeting the requirements of the law.
I really appreciate your comments, Mr. Stringer. The other comment that we had, the other testimony, was that the changes that were made to the Fisheries Act made it harder or became ambiguous so that the DFO officers did not understand the regulations and therefore could not enforce the regulations. Would you say that is true?
I think it's always difficult with new legislation, and this was certainly the case. We'd had 30 years experience, I think it was, with the Section 35, the harmful alteration, disruption, and destruction of habitat. It was absolutely clear and much jurisprudence built up on it. And with serious harm and with commercial, recreational, and Aboriginal fisheries, there have been challenges in terms of our own staff, and we've done training okay? But proponents and others to have a full understanding of exactly what that means and how it's applied.
So, but the onus would be on management and the ministry to explain that. Is that correct?
It is, and we've had training sessions across the department. That said, there was not the jurisprudence in place to be clear about the direction about that, but we've sought to be clear about the direction.
I appreciate it. Thank you. Thank you for testimony.
Thank you, Mr. Doherty. Mr. Donnelly for 7 minutes, please.
Thank you, Mr. Chair, and thank you to the department officials for being here to answer the committee's questions. Wanted to start off on the Cohen Commission. And the government updated Canadians this August on its Cohen Commission progress. And for recommendation 7, the government stated, quote, DFO has not developed an annual progress report on WSP implementation, but has reported on implementation internally through regular business planning and reporting processes. And the updated WSP implementation plan will include a commitment to report publicly on progress annually, end quote. And they further, it was further stated that, quote, it is anticipated that external consultations on the draft implementation plan will begin in 2016. So first question is, when can we expect the wild salmon policy implementation report?
What I can say is that those consultations have begun. Okay, part of the consultations are on the implementation, and in fact, the consultations are specifically on the implementation of the policy. What launched it, what the minister said when he did the Cohen announcement this summer is, we have recommitted to the wild salmon policy, right? And there were people were wondering if we remained committed to it, so recommitted to it, and said we would go out and have consultations on its implementation, and following that, we would have regular annual implementation reports, public reports. So those consultations are now underway.
And thank you. And the list of consulted stakeholders, is that publicly available?
If it's not publicly available, we can make sure this committee is aware of it. And I believe it is publicly available, but we'll make sure that you can have that. Okay. And so you're still not sure about when the report is coming, but it'll come soon. Yeah.
And the funding for the WSP implementation, is that in the budget?
It's everywhere, right? I mean, the funding for the great thing about the wild salmon policy, it is a ecosystem-based policy which has science, fisheries management, habitat, oceans, and all those elements. It actually is something that does an ecosystem-based approach.
Sometimes everywhere means nowhere.
And the funding is in all the different areas. We have said in the past that with respect to salmon, on all of those things, okay, we spend on science alone around $16 million a year, on everything around $65 million a year. So it's a substantive amount of monies, and we were actually able to put that together during the Cohen Commission to show where the funding was, and we've made a further investment, as you know, with the $40 million a year on science. That is helping. The oceans funding that we got is helping. All of those pieces fit to it as well.
Thank you. And just turning to Coast Guard, in its first quarterly report submitted to this committee on November 4th, in response to the committee's report on the closure of the Comox MTS Center, DFO indicated that there were 74 outages related to the MCTS communication control system, and in quote, 50% of the system failures were caused by third-party telecommunication issues. How does DFO manage these system failures, and what corrective measures have been established as a result?
Thank you for the question, Mr. Donnelly. In terms of the telecommunication failures, on November 8th, when the Oceans Protection Plan was announced, a major part of that plan is for us to acquire and install an entire backup system, so that there's a duplication for all of those lines. If one goes down, we'll have a backup. And that's a accelerated backup process we were putting in place, and so we're very happy to get that going. In terms of the 74 that were CCS related, the communications control system, they ranged from system failure for 30 seconds. We had a couple that were longer. If we even had to reset a computer for just reboot it, we logged it there so that we would be completely transparent on every time the system went down, anytime something was logged in the system. And so there's a range of problems. Any of the major problems, Mario can describe it in detail, have been rectified through our technical team either in the region with Frequentis or here. The majority of them were very minor. They're just there for transparency purposes.
Okay, and just to add, we know the Nathan E. Stewart ran aground spilling diesel fuel into the traditional waters of the Helsik First Nation. Some First Nation leaders are describing that as an environmental disaster, and there was recently in the Globe and Mail details how only 2 MCTS officers were responsible for monitoring that vast stretch of BC's coast from North Vancouver Island to the Alaska border inside the, or including the Inside Passage. And BC has been promised a world-class spill response. However, prevention is far less expensive. So I'm wondering if the ministry is going to reconsider or is reconsidering the reopening of MCTS Comox to help prevent these disasters.
Thank you. I read that article myself in the Globe and Mail. I think there's a couple of elements to the answer. Number one, the MCTS officers responded immediately and actually directed a large portion of that response to ensure that the search and rescue vessel deployed immediately and was on scene rapidly to respond to what was originally a search and rescue incident. We didn't know that the tanks had been breached on the tug. We saved 7 people, one of whom was in the water. So from that perspective, the MCTS function and its coordination of search and rescue and then what became a larger incident was perfect. And you heard the transmission, it was very clear. The communication with the tug was pretty much perfect. The reality of this incident, Transport Canada and the Transportation Safety Board are both investigating. More MCTS officers would not have prevented this incident. It had nothing, it was, a turn was missed. It was sort of 1 or 2 minutes and the vessel was aground. The MCTS officers did an extraordinary job in managing what was a very, very highly emotional situation. You heard the tapes yourself, as you said, and they were reported in the Globe and Mail. The MCTS had no impact other than responding and ensuring that 7 people were saved. They did a really good job.
Thank you, Ms. Thomas. I appreciate it. Thank you, Mr. Donnelly. Now we're going to go to Ms. Jordan for 7 minutes, please.
Thank you, Mr. Chair, and thank you to our witnesses for appearing today. I have a number of different questions from all over the place. I'm going to start actually with Mr. Stringer because I often remember your quote when we first talked about marine protected areas. When you first appeared before this committee, you said it was both exciting and terrifying. And I guess I'd just like you to update us on where we are in terms of the percentages and how we're moving forward with our MPA.
Thank you for the question. It continues to be both of those things. What I would say, and I think I said this at the time as well, what's most exciting about it is that it's truly galvanized the department and the stakeholders and even the fishing industry and others to say, okay, this is going to happen. How are we going to make it happen? What sorts of things are we going to do? I would say 2 things. It's quite different, I think, for 2017, the 5%, and 2020 or 2020, which is the 10%. We are now going through an exercise of identifying the sensitive areas that we have already through science identified. And those are corals and sponges. They are key rearing areas and spawning areas and looking at areas that need protection. We are also looking at what are the best tools for those protections. Okay, understanding that formal MPAs, marine protected areas, in regulations take time. So we're going to have to use other measures for the protection, and that's the exercise we've been going through this fall. We've also been talking to the fishing industry, the oil and gas industry, the shipping industry, others, to make sure that they're part of the discussion. And of course, we've been engaging with environmental groups and academics who have a lot of this information. So that's been the exercise. It's also about trying to figure out what are the criteria that we need to say, we've done this, to be able to say, okay, this counts as X%. In addition, there's been a number of specific closures. So there was a significant canyon closure off of Nova Scotia, which was announced, I think it was early September. Okay, there was Darnley Bay in the north, which was announced very recently, and there have been others. So the other thing I would say, it's not just DFO, even in the federal government. Parks Canada does national marine conservation areas, and they are working on Lancaster Sound, which, should they get it, gets 2%. Okay, and that's a major one up in the Northwest Passage. And Environment Canada does national wildlife areas, and they're working on Scott Island, which is on the north end of Vancouver Island. So we've got structure and organization within the government. We're working with environmental groups, we're working with industry, and we're trying to figure out, A, how we get to that 5%, and B, how we get the more formal MPAs in place by 2020.
So could you just kind of walk us through the process of engaging with the stakeholders on the MPAs? I mean, you mentioned fisheries, you mentioned oil and gas, you mentioned, do you just hold a public meeting? Do you reach out to them individually? I guess, coming from an area with a number of fishermen, I would just like to know how that process works.
So taking Nova Scotia as an example, there is a process underway which brings together the fisheries organizations, okay, other industries, and that's been meeting for many, many years. There's something called ESSM, which stands for Eastern Scotian Shelf Integrated Management Area, okay, and that has continued to meet, and it's become the core of what's been dealing with these protected areas. So they've been working on MPAs, but they're also working on different areas for closed areas. The challenge we're going to have is, in previous days, to be honest, we used to take 7 years. Okay, we'd identify, here's the areas that need protection, here's 14 different candidate areas, what do you think, where are the interests, et cetera, and it would take years and years and years. We've given ourselves 1 year. To be able to do this. It's a huge challenge. People do feel hurried. They do feel rushed. Okay? That said, we do have the science to be able to do it. We are looking at different measures that help ensure that we're going to maintain a robust fishery and other industries. And we are working as much as we can with industries going forward. But that is a bigger challenge than it was.
Okay. I'm going to switch my questions now to small craft harbors specifically. And as you may or may not be aware, the size of vessels is changing in terms of the lobster industry. And specifically, they're now a lot wider than they used to be. This is causing a lot of problems with our wharves, with our small craft harbors. And in terms of, the amount that they can now berth, the size of the berth, the getting in and out of areas, breakwaters. And I guess my question is, when you look at wharves that need upgrades, do you take into account, I think this is part of the problem that we see, is that they're not taking into account the changes that are happening in the fishery when they are upgrading the wharves. And sometimes they run out of money before they run out of the project. I have one wharf, for example, in my riding where there's a 3-foot difference because they didn't have enough to finish the whole wharf. And now the two sides of the wharf have a 3-foot difference, and they have ramps, which I question the safety of, getting to and from. So I'm just wondering the process in terms of when you look at small craft harbor wharves, how do you determine the best approach in terms of the way the fishery is going?
So I would say thank you very much for that question. It is a huge challenge. We do try to integrate our small craft harbors group as much as we can with our fisheries groups, as well as to engage with the harbor authorities. And the harbor authorities have made an enormous difference. Those are the folks that really know what the future needs are, and so we work with them as much as we can. But I think we need to do better at that, ensuring that we're not just patching up, that we're actually preparing for the future. The investment that this government made this year, I said that $75 million a year is the usual budget for this, $149 million over the next 2 years. Enormous difference in terms of being able to catch up and to be able to not just patch up, but actually think ahead. The other thing I would...
Thank you, Mr. Stringer.
Okay.
I have to leave it at that, sorry.
No, understood.
We have to move along. Mr. Sopek for 5 minutes, please.
We had some very interesting testimony earlier from Mr. Ron Bonnet, who's president of the Canadian Federation of Agriculture, Canada's largest farm group, regarding the Fisheries Act. I'm going to quote his testimony. He said, regarding the Fisheries Act in its previous form, the experience that many farmers had with the Fisheries Act, unfortunately, was not a positive one. It was characterized by lengthy bureaucratic applications for permitting and authorizations, and a focus on enforcement and compliance measures taken by officials, coupled with the lack of guidance or outreach on the purpose of these measures or information on how to navigate through the process. Many farmers were then relieved when the changes that were made just a few years ago drastically improved the timeliness and cost of conducting regular maintenance and improvement facilities to their farms, as well as lifting the threat of being deemed out of compliance. Mr. Bonnet went on to say, there are also many accounts of inconsistency in enforcement, monitoring, and compliance across Canada, with different empowered organizations, would lead to a confusion and indiscriminate approaches to enforcement and implementation. Even at the individual level, there were different interpretations of the Act based on one's familiarity with agriculture. Mr. Bonnet went on to say, it is CFA's position that a complete revert to reinstate all provisions of the Fisheries Act as they were would be unproductive and reestablish the same problems for farmers and provide little improvement in the outcome for the protection and improvement of fish habitat. The current streamlined approach is working far better for all, and efforts should continue this approach. Why was the agricultural community's experience in terms of interactions with your department so dismal before the changes were made to the Fisheries Act?
I think you've heard from the agriculture community about their views about why it was the challenge that it was. I'd say a couple of things. One is it wasn't all dismal. We actually did have some class authorizations for agricultural drains in Ontario and in other areas. So we were working with the agricultural communities. I would also say it was true that there was a number of notorious, if you might want to say, instances where where farmers were concerned that people were coming onto their fields and either making them clean out their drains or not letting them clean out their drains or making them do it in a certain way. But in terms of that question, we've always sought to work as closely as we can with all groups.
I understand that, but as somebody who, as you know, is a fisheries biologist and represents a large rural area, I think with all due respect, Mr. Stringer, you're kind of downplaying the impact on municipalities and farmers across the country. We have testimony from the Saskatchewan Association of Rural Municipalities, the AAMDC, which is the municipal association in Alberta, the Federation of Canadian Municipalities will be before us. So I deeply respect your expertise and testimony, but I would say that as somebody who represents the farming and rural constituency and knows pretty much all the farm leaders across the country, the experience with the old Fisheries Act was uniformly bad. And I think it's partly because, when a DFO officer shows up at a farm meeting with a flak jacket and a pistol, of course, we farmers love our guns, but that's a different story. We don't take them to municipal meetings. And so I would just say that was an experience that no matter what changes are made to the Fisheries Act now, I would just like the department to really reflect upon and ensure it doesn't happen. That's more of a comment. I just switching gears a little bit here on a more positive note. The fact that the department is hiring all these fisheries scientists, what kind of process will you go through for the allocation of these scientists to various programs? And I think I'm maybe speaking for the entire committee. As you know, we're doing a major study on the northern cod and the Atlantic salmon, two species of tremendous importance. Would you ever possibly see the way to assigning some of these new scientists specifically to a group to Atlantic salmon and a group to northern cod, so they don't just quote unquote work on what they want to? And I mean that respectfully, because I love doing fisheries, which is it's great fun. But these are two species that are that are extremely important. And do you see the possibility of assigning a number of scientists to each one of those species, and that's all that they would work on?
Thanks.
Thank you.
Trevor Swordfinger would have the specific answer to that. I believe some of them will be actually assigned to those areas. What I can say is, it was a very significant amount of money. It was $40 million a year plus $1.5 million a year for freshwater. So that does speak to the issues around fisheries protection, the freshwater part in particular. But on that $40 million a year, more than half of it goes to stock assessment, okay? And stock assessment and related fisheries science. So, and that's an area that has not had an investment in a long time. And that is the assessments around cod, around salmon, those types of things.
One question, Mr. Chair.
Sorry,
anything for fisheries enhancement?
So there's funding that goes. The funding goes to fisheries I don't know if it's enhancement specifically, but I do know that it is fisheries biology and stock assessment is more than half. There is a percentage for aquaculture, there is a percentage for freshwater science, and there's a percentage for ocean science writ large. So it's been very thoughtful about areas that we needed the most work, and where we're hearing from fishermen in particular where that work is needed.
Thank you, Mr. Stringer. Thank you. Now I'm going to have to go to committee about this one. We have approximately about 5 minutes left, but what we can do, well, a little over that, we're going to go to, or perhaps not. Ms. Jordan was up for 5 minutes. Is that correct? Oh, no, I'm sorry, Mr. Morrissey. My apologies. Beyond that, to round out, we can go to Mr. Donnelly for 3 minutes. Then we have to take votes very quickly, which means I need to extend the meeting by 5 minutes. Do I have unanimous consent to proceed in that fashion? 5, 3, and then votes. All right, we're good. No objections. Mr. Morrissey, very quickly, 5 minutes or less.
Oh, thank you. Just a couple. I have to reiterate the comments made by my colleague, Mr. Sopak, on we have to get a lot better in dealing with farmers and with municipalities on the interpretation of the Act as we tighten it up. There was too many cases of borderline heavy-handedness coming from the department in dealing with these people who generally are trying to do the best job they can. I want to go to the small craft harbors and follow up with Ms. Jordan. In the money that you have going forward, could you just elaborate a little bit on what you're going to utilize the 1.4? How is it going to impact on the capital expenditures going forward?
The 1.4, which one is that? Do you know?
The 1.4.
Can you find it? So thanks for the question. I will just, in terms of, and I'll start with where you started, which is around the agriculture, but also the interpretation of the Act. And I did say it the last time when, and the minister said this, but I also said this. There is more room for interpretation around commercial recreation and Aboriginal fishery. There is more room for interpretation around serious harm to fish than there was in the previous version on habitat. With respect to the 1.4 million, which one is that one?
It's funding to support projects for small craft harbors, Lance au Griffon, using the funding for a divestiture project.
That one is that's a divestiture program that was actually originally booked for Little Tancook Harbor, okay, in Nova Scotia. It looks like that particular divestiture is not going to happen, at least not this year. We're hoping that it will happen. So it's a question of diverting the funds to a different project, which is in Quebec. There is 2 other small craft harbor items in here, which are to approve funding for small craft harbor work in Naufrage and in Alberton, okay? So those are projects that we were hoping to do last year, and we've moved the funds to this year because it didn't get done in time, and we wanted to make sure that work is done. I believe the work's being done in both cases. There's fixing the wharf and dealing with the breakwater.
Okay. Could you give a breakdown? You identified $5 million, I believe, in grants you were transferring. What were those?
$5 million in grants.
Oh, that was Mr. Madison.
Yes, we have in these estimates we've asked for $5 million in grants and contributions. Most of it is for contributions, and I do have the breakout. If you give me a few minutes, I can get the breakout by initiative.
Oh, probably you could table them. I don't want to use my minutes with you looking through your book.
We can get you that information.
The other is your capital. You identified 1.6 million you were transferring to capital. Could you also identify what that was for?
Yeah. We can get you that information as well.
Okay. Oh, I looked for that. Probably we could go back. Could you just elaborate a bit more on? It was Newfrage and Alberton. You said. Could you identify what the funding options were there?
So it's a total amount of $360,000 that is being moved from last year's funding to this year's funding to be able to complete the work on those projects. Newfrage is construction of a wharf and repairs to the breakwater. Alberton is wharf repairs. Newfrage, I know, is completed, and Alberton should be done in a couple of weeks. Why it's in the supplementary estimates is it was supposed to be in last year's funds. Didn't get done last year, so we needed to move monies over to this year's funds.
1 minute.
1 minute.
Oh. And how do you could you elaborate a bit on the impact you will have with your new capital expenditures for small craft harbors going from 75 to 149 million, I believe you said. Is that 149 million each year over the next 2 years?
No.
Or 149 spread over two?
So yes, it's the latter. So in other words, we get $75 million a year. That's the A base, and it's ongoing. We get it every year. This year they said we're going to give you $149 million over 2 years. Okay, so it's and it didn't say how we had to divide it up, but we actually have done that. With that $149 million, we're doing 85 projects. Okay, so it's around $2 million a project. So these are substantive projects. It's in every region of the country, and these are largely project-ready things because we've got a list of lots of them that need work. So it does really enable...
Do you have that list now?
I think we can certainly provide the list of where those projects are, and most of them have been announced and work's underway on them.
Okay, thank you, Mr. Stringer. Thank you, Mr. Morrissey. Mr. Donnelly for 3 minutes, please.
Thank you, Mr. Chair, and I have a couple of questions. I wanted to start off with the Fisheries Act, and you've identified $3.4 million in funding to review the changes to the Fisheries Act and to enhance monitoring and reporting of existing projects permitted under the Fisheries Act. Mr. Stringer, could you just explain a little bit more about how that money will be spent? And one of the concerns that we have or certainly I have at this committee, is not having enough time to hear fully from all the witnesses that want to comment on the Fisheries Act. So is there is this funding going to allow for a fulsome input of Canadians who have concerns in the limited time, and do you have time to spend this funds?
So, you know, we're going to make sure that we do hear from as many Canadians as we can. The funding, in terms of the engagement, there's, as you know, we've got, I think the minister spoke to, we have a federal provincial table that's working on this. Deputies meeting with provinces today on the Fisheries Act and other issues. We've got the what the committee's doing, which is we very much look forward to that report. But there are other elements as well. There's Indigenous consultations, and Indigenous consultations. Some of this funding is to support that, to support Indigenous groups to do some work, to come to the table, to work with us, etc. And the online engagement, right? That process, setting up that website. Being able to pull the data off, etc., that is covered in this funding. The monitoring. So we, you know, there has been the challenge. We want to fully engage Canadians, take the time to think through what we want to do, and we want to make progress immediately. So we said, let's at least enhance the monitoring. Let's at least develop a monitoring protocol and start doing more and commit to a report in terms of how we're doing in monitoring. And there's 7 FTEs or 7 people that have been brought on to be able to do that work. So that's what the $3.4 million is for.
Thank you. And I've heard some First Nations, they're very frustrated in terms of how they can get involved, and certainly in front of this committee. I've talked about the Heiltsuk First Nation today, and I've talked about others in the Lower Fraser, the fisheries, Aboriginal fisheries group. So there's others that have been writing to us and expressing their concerns. In the remaining seconds that I have on the 11.8 million that has been designated for marine conservation, the MPAs. I just want to say, according to the fall 2012 report of the Commissioner on the Environment and Sustainable Development, DFO has established 8 MPAs, marine protected areas, and is working on another 8. Can you update us on that? And do you think you'll hit the 2017 target by the end of that year, next year?
We intend to hit the target next year. Okay. In 2017, remembering that 2017 starts soon, but ends a year from now in a bit.
So we're at about just over 1%.
So we are going to hit that.
We're going to hit 5%?
Our plan is to hit that target. Okay, we're taking it very seriously. It doesn't mean that all needs to be formal MPAs. Those extra 8 MPAs, which we are working on, okay, including Hecate Strait and Laurentian Channel and St. Anne's Bank, and those are the ones we've been working on. That doesn't get us to 5%. To get to 5%, we're going to have to count other measures. And the HE target 11, that resolution says, through marine protected areas and other effective area-based measures. So we've been working on making sure that we meet the criteria for real other effective area-based measures, and understanding that by 2020 we've got to live up to that.
Thank you very much,
So our plan
folks.
is to make it.
Thank you, Mr. Stringer. I'll have to leave it at that. As you know, I want to thank Mr. Pelletier, Ms. Thomas, Mr. Stringer, Mr. Matson for joining us for these supplementaries. Don't go anywhere. We have to do some votes here just to end off this meeting. Of course, we have 3 votes in this particular round for the supplementary estimates B, referred to us and when was that? November, was it? November 3rd, yes. So 1B, operating expenditures, 5B, vote on capital expenditures, 10B on grants and contributions. So shall vote number 1B carry? Agreed? Agreed. Any objections? Seeing none. Shall vote number 5B carry? Agreed? Any objections? Shall vote number 10B carry? Agreed? Seeing no objections, done. That being said, shall I report the votes on the supplementary estimates back to the House of Commons? Agreed. Any objections? Done. Thank you very much, everybody. We will see you next Monday.
In the House.